The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law, and today we're going to talk about non-compete agreements and answer the question, when is a non-compete agreement enforceable? So first let's talk about what a non-compete agreement is. A non-compete agreement is an agreement between an employer and an employee that during the term of the employee's service with the employer and after the employee's job is terminated for a particular period of time, the employee is not going to engage in competitive activities with the employer. It's really a balance between restraint of trade on the one hand that we don't want to see, but also protecting an employer's investment in an employee. We don't want the employer to give the employee a bunch of skills, experience, and trade secrets only to have them immediately jump ship and go take that information and skills to a competitor. So oftentimes when an employer is going to hire a skilled and important employee, they'll include in the employment agreement a non-compete clause that prevents them from directly competing with the employer for a particular period of time. So this is often the subject of litigation about whether this can be enforced, because employees obviously want to go and use those skills that they've gotten in the marketplace. So the issue is generally whether the non-compete clause is too broad. In order to be enforceable, a non-compete clause has to be properly limited in scope. And the issue is whether the scope is reasonable. And this comes down to three things that courts have to weigh. One is, does the non-compete agreement actually protect a legitimate business interest? Two, does the non-compete agreement place an undue hardship on the employee? And three, does the non-compete agreement violate public policy? So as far as the non-compete agreement protecting a legitimate business interest, that comes down to really three things: geographic scope, the amount of time that it lasts for, and the type of activity that it protects. So let's look at each one of those three things one at a time. So the simplest is geographic scope. The non-compete agreement has to be limited in geographic scope to an area that the employer actually does business or is planning to imminently do business in the future. So if you just do business in Naperville, then you can limit your non-compete agreement to a 5-mile radius of your Naperville office. You can't really say all of the state of Illinois is barred from the employee competing from you, because you don't want to make it so that they can't ply their trade anywhere in the world. It's just where you're actually doing business. You don't want them competing with you. If you are doing business in the entire state of Illinois, then you can say that they're not allowed to compete in the entire state of Illinois. If you're doing it nationally, then it can be in America. But the test is really where the employer is actually doing business. Time is also important. Generally, we look at a 5-year duration for non-compete agreements. If you're going any longer than 5 years, you're running the risk of it being unenforceable. The more important the employer's job and the more key information that was shared with them, the more likely courts are going to allow a longer duration for non-compete agreements. Finally, the type of activity is also important. You have to actually specify the particular thing that the employee can't do to compete with you, and it has to be the type of activity that is a legitimate business interest for you to protect. So you can't just say the employee can't work at too broad of a type of competitor. It's got to be something that actually competes with your business and a type of role that actually competes with your business. Finally, a non-compete agreement actually requires independent consideration. So consideration is quid pro quo. That is, I'm getting something in return for signing the non-compete agreement if I'm the employee. Now, if you do this as part of their employment contract, that means that's consideration right there. The consideration is that they're getting a job, and in return they're signing this non-compete agreement. But if they already work for you, you can't just force them to sign a non-compete agreement. Sure, they can sign it, but it won't be enforceable unless it's tied to some sort of bonus or something that they weren't going to have anyway as part of their job. Now, non-compete agreements, like I said, if they're properly limited in scope to a legitimate business interest, tend to be enforceable by courts. However, there are other alternatives that are less scrutinized, and these are non-solicitation clauses, non-disparagement clauses, and trade secret clauses. A non-solicitation clause basically says that the employee can't offer to have other employees or customers come with them to a competitive business. So they're allowed to work for competitive business if there's not a non-compete clause in place, but they can't kind of poach the customers and employees of the original employer. And courts are much less likely to scrutinize whether this is properly limited in scope than a non-compete agreement. Non-disparagement means that they can't say anything negative in public about the employer. And a trade secret clause means that they're not allowed to share certain specific trade secrets that they've learned at the employer with competitors. And these are much more easily enforceable than a non-compete clause, although, again, if the non-compete clause is limited in scope, it will be enforceable. So if you have any questions, you can leave them in the comments section below this post at learn-about-law.com or below the video on our YouTube station. If you found this helpful, please subscribe to us on Apple Music, SoundCloud, YouTube, or our email list, which you can sign up for at our website, learn-about-law.com. If you need some help, give us a call at 630-324-6666. That's 630-324-6666. We offer free consultations in many areas of law, and we have offices all around Chicagoland for your convenience. Thank you so much for watching and listening.
Thanks so much for watching our video. If you have any questions, feel free to comment below. Click the subscribe button for new videos every week, and download and review us on iTunes. Visit learn-about-law.com for other legal-related articles and videos. Visit our business podcast and video blog, seizeyourbusiness.com, and visit Making Real Estate Fun for real estate videos and podcasts. Call us at 630-324-6666 for a free consultation.